Ready? Exercise number 82. Legal matter. Start. The questions which arose for consideration in the instant appeals were whether persons appointed as superintendents in aided non-governmental hostels are entitled to claim absorption by way of regularization in government service or salary on par with superintendents in government hostels, and whether part-time cooks and chowkidars appointed temporarily by mess committees of government hostels with 2 or 3 years service are entitled to regularization by framing a special scheme. Allowing the appeals, the court held that the High Courts, in exercising powers under Article 226 of the Constitution, will not issue directions for regularization, absorption, or permanent continuance unless the employees claiming regularization had been appointed in pursuance of a regular recruitment in accordance with relevant rules in an open competitive process against sanctioned vacant posts. The equality clause contained in Articles 14 and 16 should be scrupulously followed, and courts should not issue a direction for regularization of services of an employee which would be violative of constitutional scheme. Stop. Next para. While something that is irregular for want of compliance with one of the elements in the process of selection which does not go to the root of the process can be regularized. The backdoor entries and appointments contrary to the constitutional scheme and or appointment of ineligible candidates cannot be regularized. Mere continuation of service by a temporary or ad hoc or daily wage employee under cover of some interim orders of the court would not confer upon by him right to be absorbed into service. As such, service would be litigious employment. Even temporary, ad hoc, or daily wage service for a long number of years, let alone service for 1 or 2 years, will not entitle such employee to claim regularization if he is not working against a sanctioned post. Stop. Sympathy and sentiment cannot be grounds for passing any order of regularization in the absence of a legal right. Even where a scheme is formulated for regularization with a cut-off date, that is, a scheme providing that persons who had put in a specified number of years of service and continuing in employment as on the cut-off date. It is not possible to others who were appointed subsequent to the cut-off date to claim or contend that the scheme should be applied to them by extending the cut-off date or seek a direction for framing of fresh schemes providing for successive cut-off dates. Stop. Next para. Part-time employees are not entitled to seek regularization as they are not working against any sanctioned post. There cannot be a direction for absorption, regularization, or permanent continuance of part-time temporary employees in government run institutions cannot claim parity in salary with regular employees of the government on the principle of equal pay for equal work, nor can employees in private employment, even if serving full time, seek parity in salary with government employees. The right to claim a particular salary against the state must arise under a contract or under a statute. Stop. Next para. The respondents in the instant appeals were appointed in pursuance of the Government and Aided Hostels Management Rules 1982, which were issued by the state government on 18/1/1982. Though they were referred to as rules, they were not statutory rules framed by the state government in pursuance of any power vested in the state by the legislature under any enactment. They were more in the nature of executive instructions and guidelines framed for administrative convenience. The said rules were intended to apply to government hostels run by the Social Welfare Department, as also aided hostels which received any aid in the form of grant from the Social Welfare Department. In so far as aided hostels are concerned, the government is liable only to extend aid by way of a grant of students of 6 to 8 standards and students of 8 to 11 standards staying in such hostels to meet the expenditure of food, water, electricity, clothes, hair cutting, soap, oil, and shoes, and another grant for books and stationery of such students. The government is not liable to bear the expenses of salary and allowances of the employees of the aided hostels, and it is for the private organizations which run the aided hostels to meet the salaries of employees from their own resources. The persons employed in the aided hostels are the employees of the respective organizations running those hostels and not the employees of the government. The government has merely prescribed the eligibility conditions to be fulfilled by the private organizations to get grants to meet the food and education expenses of students staying in such hostels. Therefore, under no stretch of imagination, persons employed by aided hostels could be termed as persons employed by the state government. Full stop. Thank you very much. Guys, again I am requesting, please always try to repeat the matter, then only your fluency and accuracy on steno will improve. And also there is one more request, please subscribe my channel so that you can get the first notification on legal and general matter. Thank you very much guys.